Hello and welcome to Daily News Simplified. Here we will take up the news articles from The Hindu of Delhi edition and discuss them as per the demands of UPSC Civil Services exam. The topics for today's discussion are listed on your screen. Let us begin our discussion. The first article of today's discussion is based on this particular news, which has appeared on page number 3 in The Hindu. It basically talks about the political situation in Tamil Nadu, which has become tense following the comments made by the governor, Mr. R.N. Ravi, regarding the power of governor to withhold the bills. And the ruling DMK party has announced an agitation calling for governor to stop the activities that has lowered the assembly's dignity. As this news is directly related to governor and his powers, which is an important area in General Studies paper 2 of our UPSC mains exam. It has directly mentioned the structure, organization and functioning of executive and constitutional posts. So this area becomes important for our discussion. Moreover, in the year 2022, UPSC has specifically asked a question on the legislative powers of governor. So today we will try to analyze the aspects related to governor, how he is appointed, what are the qualifications required, powers and functions of governor, and the issues which are associated with the office of governor, and finally we will see few recommendations regarding the same. First of all, we will see who governor is. As Article 153 to 167 of Part 6 of the Constitution deals with the state executive, Article 153 specifically deals with governors of the states. Further, he is the chief executive head of state. He is also an agent of center government. Hence, he plays a dual role in Indian political system. Further, there is a provision in the Constitution that there will be a governor for each state. But the 7th Constitutional Amendment Act has facilitated the appointment of same person as governor for 2 or more states. So this was the basic about governor, the constitutional provisions and what role he plays in the state executive. Now we will analyze the appointment of governor. Many of you must be aware that governor is neither directly elected by the people nor indirectly elected by specially constituted electoral college, as in the case of president, who is elected by a specially constituted electoral college which constitutes the elected MPs of both houses of parliament, MLAs of state assemblies and MLAs of Union Territory of Delhi and Puducherry. The governor is appointed by president by warrant under his hand and seal. So there is no specific provision for the appointment of governor. Further, the Constitution of India has mentioned 2 qualifications for the appointment as a governor. The first one is he should be citizen of India, and the second one is he should have completed 35 years of age. Just try to remember this particular fact as it can be asked in prelims exam also, and you should be aware that there are only 2 qualifications which are mentioned in the Constitution for appointment as governor. Further, the term of office of governor. A governor holds an office for a term of 5 years from the date on which he enters upon his office. But this term of 5 years is subject to the pleasure of president. He can be removed by president at any point of time, and it is one of the major issues associated with the office of governor. And he can also resign by giving resignation to the president. Here we have discussed about appointment, qualification and term of office. Now we will analyze the powers and functions of governor. Like president, governor is also entrusted with extensive powers. The first one is executive powers. The executive power of governor includes the appointment of chief minister and other ministers on the advice of chief minister. Further, he also appoints the state election commissioner and advocate general of the state, and he can also recommend the imposition of constitutional emergency in a state to the President of India, and during that period he enjoys the executive powers as agent of president. Further, he also has the financial powers, and the first one is related to money bills and the other one is finance commission. Now money bills is an important financial power which is being given to governor under the constitution. Many of you must be aware that money bills can be introduced in state legislature only with the prior recommendation of governor. So it is an important financial power of governor. Further, he constitutes the finance commission after every 5 years to review the financial position of panchayats and municipalities. Now it is different from the finance commission which is constituted by President of India under Article 280, which deals with the distribution of taxes between state and center. The next one is judicial powers. Like President of India, governor of state is also being given the judicial powers, and under which he can grant pardon, reprieve, respite or remission of punishments of any person convicted of any offense defense against any law relating to a matter to which the executive power of state extends. As we are discussing the judicial powers, one must be aware about the special case of death sentence in which governor cannot pardon the death sentence. The pardoning power related to death sentence can only be exercised by President of India. Try to remember this fact, as it can be asked in the UPSC prelims exam also. Further, the legislative powers. Now, under the legislative powers, governor can summon or prorogue the state legislature. He also have wide powers with respect to the bills passed by state assembly. We will discuss this in detail in due course. Now we will analyze the issues related to the office of governor, as this office has been in news due to various controversies, whether it was case of West Bengal, Kerala, Tamil Nadu or Punjab. So one must be aware about the key issues which are associated with this particular office. The first issue is related to the appointment. As there is no procedure mentioned in the constitution regarding the appointment of governor, he can be appointed on the wills of central government, and there might be a chance that a person who is politically motivated can be appointed as a governor to further the interest of the ruling party. So it is an important issue related to governor. Now the second issue is removal of governor. As there is no security of tenure which is provided to governor, he can be removed at any time on the will of central government. Moreover, there is no provision of impeachment of governor like that of president. He does not have any security of tenure. The third one is discretionary powers. The governor has been given constitutional and situational discretionary powers which are often misused by the governor. Now the constitutional discretionary powers include the reservation of bills for the president. Now let us assume a person is appointed as a governor in a state which is being ruled by a different political party as that of central government. The bills passed by that particular state assembly can be reserved by governor for the consideration of president, which can impact the governance of that particular state. And there is another constitutional discretionary power which is given to the governor, is related to the recommendation of imposition of president's rule in that particular state. And if the president rule is imposed in a state, the council of ministers will be dismissed and the functioning of state government came to a halt. It is an important issue of contention between the center and state governments and makes the role of governor controversial. He has also been given the situational discretionary powers, and they are associated with the situations occur in that particular state. The first one is the appointment of chief minister when no party has clear-cut majority in state assembly. And there are many recent examples to this particular situation which we have witnessed in Madhya Pradesh and Maharashtra. Hence, it is an important issue related to the office of governor. Now we will analyze the powers of governor with respect to the state bills, and it became a point of contention between the state of Tamil Nadu and the governor. The Article 200 of the Indian Constitution empowers the governor with respect to state bills with 4 options. The first one is he can give assent to the bill. The second one is he can return the bill for the reconsideration. The third one is he can withhold his assent. And the fourth one is he can reserve the bill for the consideration of president. Now we will analyze all the 4 options and see what happens if one of them is exercised by governor. If he gives the assent, then the bill becomes an act. And if he returns the bill for the reconsideration by the state assembly, then the state assembly has to reconsider it. And if the state assembly passes the same bill to the governor, then he has to give assent to that particular bill. And this power of governor is known as suspensive veto. The third one is withhold the assent. If governor withhold his assent, then that particular bill is dead and does not become an act. The fourth one is if he reserves the bill for the president. It is a special case specifically mentioned under Article 201 of the Indian Constitution. Now we will see what will happen to the bill if it is being reserved by the governor for the consideration of president. Now let us try to understand the Article 201 of the Indian Constitution, under which the bills are reserved for president's consideration. When a bill is reserved by governor for the consideration of president, he has 3 options. The first one is he can give assent to the bill and then bill becomes an act. The second one is he can withhold his assent and the bill becomes dead. And the third one is the return of the bill to the state assembly. When such a bill is returned, the state assembly should reconsider it within a period of 6 months from the date of receipt of such message. And if the bill is passed by the House, again with or without amendments, and presented to the president is not bound to give his assent. He may give assent to the bill or withhold his assent, which is not in the case of parliament. If parliament passes a bill and gives to president for his assent, And if President returns the bill for the reconsideration and Parliament passes the same bill again, then President is bound to give assent to the bill, and not in the case of state legislature. Try to remember this fact as it can be asked in the prelims exam also. Further, we will also discuss the powers of governor with respect to money bill. If the money bill is passed by state assembly, then governor has three options. Either he can give assent, withhold, or reserve the bill for president, but cannot return. Further, if the money bill is reserved for president, he also has only two options, whether to give assent or to withhold. He cannot return the money bill. Try to remember this piece of information that a money bill cannot be returned either by governor or president. How many of you are aware that there is one situation in which it is obligatory on governor to reserve the bill for the consideration of president? You can write your response in the comment section. And that particular situation is when the bill passed by state legislature endangers the position of state high court. Then it becomes obligatory on governor to reserve the bill for president. So we have discussed the powers of governor with respect to the state bills. Now, as we have discussed the issues with respect to the office of governor, what can be the way forward? We can take a note from two commissions. The one is Sarkariya Commission and the other one is Punchi Commission. The Sarkariya Commission of 1983 gave few recommendations related to the office of governor. The first one is related to Article 356. And Sarkariya Commission said that Article 356, which is related to the President's rule, should be used in extreme cases as a last resort when all the available alternatives fail. And the second recommendation is the procedure of consulting the Chief Minister in appointment of governor should be prescribed in the Constitution itself. This is the second recommendation. And the third one is the fixation of tenure of governor. And it should not be disturbed except for some extremely compelling reasons. So these are the recommendations which you can write in your mains exam if such a question will be asked. And the second one is Punchi Commission of 2007. It broadly gave two recommendations specifically related to governor. The first one is related to fixed tenure. The Punchi Commission also said that governor should be given a fixed tenure of 5 years and their removal should not be done at the will of center government. And the second one is the fixation of time to act. Now what does it mean? In respect of bills passed by state assembly, the governor should take decision within 6 months whether to grant assent or reserve it for the consideration of president, because there is no time limit imposed under Article 200 and 201 on governor whether to give assent or to reserve the bill for the consideration of president. Whenever a question on governor or the issues related to governor is asked in mains exam, you can write the recommendations from these two commissions which will bring more authenticity to your answers. Now we will go for a quick recap. Firstly, we have discussed the context, its relevance for the exam. We have discussed the constitutional provisions related to governor, the appointment, qualification, the term of office, the powers and functions of governor, the issues associated with the office of governor, the powers with respect to state bills, and finally the recommendations, and finally the way forward by including the recommendations from Sarkariya Commission and Punchi Commission. Moving on to the next article for today's discussion, which is based on this particular news, which is related to the Great Nicobar Island project. Now this project is in news because the Eastern Bench of National Green Tribunal has ordered a stay on the Great Nicobar Island project and set up a committee to revisit the environmental clearances granted by Ministry of Environment. Now this area becomes important for our discussion from prelims point of view. As in the year 2018, UPSC has specifically asked a question on NGT and Central Pollution Control Board. Hence, one should be aware about the key aspects associated with this particular tribunal as it holds immense importance for upcoming prelims exam. Now in this question, the two statements are given. The first statement says NGT has been established by an act, whereas CPCB has been created by an executive order of government. It is an incorrect statement. Both NGT and CPCB are created under the Act of Parliament. NGT was established by the National Green Tribunal Act 2010 and CPCB was established under Water Act of 1974. Hence, the statement 1 is incorrect and the second statement says NGT provides environmental justice and helps reduce the burden of litigation in higher courts, whereas CPCB promotes the cleanliness of streams and wells and aims to improve the quality of air in the country. Both the statements are correct, and the answer to this question is B, which is 2 only. Now we will discuss the key aspects associated with National Green Tribunal. It is a tribunal set up to address the environmental issues. It can be related to deforestation, the river valley projects, and the developmental projects like Great Nicobar Island project. And it is a statutory body established under National Green Tribunals Act of 2010. Try to remember this fact that it is a statutory body. Now we will see the composition of this tribunal. The tribunal has presence in 5 zones: North, Central, East, South and West. And the principal bench is situated in North Zone, which is headquartered in Delhi. So this tribunal has 5 zones and its headquarter is located in Delhi. The Central Zone bench is situated in Bhopal, East Zone in Kolkata, South Zone in Chennai and the West Zone in Pune. And the tribunal is headed by a chairperson who sits in the principal bench, and it has at least 10 judicial members and at least 10 expert members. Now who can be appointed as a chairperson of NGT? A person who is a judge of Supreme Court or a Chief Justice of High Court can be appointed as a chairperson of NGT. Now we will see the objectives of NGT. The first one is effective disposal of cases relating to environmental protection and conservation of forest and other natural resources. The second one is enforcement of any legal rights related to environment. The third one is giving relief and compensation for damages to persons and property. The fourth one is the tribunal has 3 courts in the principal bench in Delhi to encompass all states and union territories. The fifth one is the tribunal shall be guided by the principles of natural justice and not bound by the Code of Civil Procedure 1908. Keep a note of this piece of information. And the last one is, it is mandated to endeavor for disposal of applications within 6 months of filing. So this fact can be asked directly in a prelims exam, that NGT sets a timeline for disposal of cases. To take forward our discussion, we will see who may submit cases to National Green Tribunal and what sort of cases are heard. Any person seeking relief and compensation for environmental damage involving subjects in the legislation mentioned in the Schedule 1 of NGT Act 2010 may approach the tribunal. And which statutes are mentioned in the Schedule 1? The first one is Water Act of 1974. The second one is Water Cess Act 1977. The third one is Forest Conservation Act of 1980. The fourth one is Air Act of 1981. The fifth one is Environmental Protection Act 1986. The sixth one is Public Liability Insurance Act 1991. And the last one is Biological Diversity Act of 2002. Now any case which falls under these acts can be filed to National Green Tribunal. And one important piece of information is that the cases under Wildlife Protection Act of 1972 are not dealt under National Green Tribunal. And to summarize our discussion, first of all, we have seen the context, its relevance for the prelims exam. We have also seen what this tribunal is, its composition, the objectives of NGT, and the cases which can be heard by NGT. Try to remember this information as it can help you in your prelims exam. Now moving on to the next article, which is based on this particular news, which has appeared on page number 5 in The Hindu. It basically talks about the religious riots which happened during a festival celebration in West Bengal. The context of this news is important for General Studies Ethics paper. As a case study can be asked on such an issue, we will try to discuss the ethical issues involved in such cases and what should be the way forward to enrich our cultural diversity so that we can protect and promote the slogan of unity in diversity. If you go through this article, you will get to know the key facts associated with this particular case. It highlights the festive rich culture of India and showcase the trail of mistrust and violence. Let us try to assess the stakeholders which are involved in the case. The first one is the religious communities, as the riots happened between 2 religious communities, so they are the prominent stakeholders. The second one is the common people who are affected by this particular incident, the state administration who has the responsibility to maintain the law and order situation in the society. The fourth one is central government, as court has directed the state to deploy central forces, so central government comes into picture. The fifth one is political parties, and the sixth one is the religious leaders of the both communities. These are the broad stakeholders which are involved in the case. So whenever you come across a case study, just try to create a mind map of stakeholders so that while dealing with the ethical issues and way forward, you should not miss the main stakeholders. Now we will analyze the ethical issues involved in the case. So the first one is the lack of virtue of tolerance. As Raus is often considered as the last and worst form of intolerance, it is against the spirit of brotherhood on which the concept of unity in diversity holds. The first issue is lack of virtue of tolerance. The second one is the politics without principles. In this particular case, the religious divide and polarization being done by the political parties to reap the political gains. So it highlights the politics without principles, which is one of the Gandhian sin. The next one is using festivals as a political tool. The festivals are celebrated in the country to promote the spirit of brotherhood. But in many cases, we have seen that the festivals are being used by the political parties and political leaders to polarize the masses. So it is again an ethical issue in which the cultural elements are being used to further the political gains. The fourth one is lack of wisdom. As many of the youngsters are involved in that particular riot, and it shows the lack of wisdom among the youth, who are seen as future of the nation. Hence, it is a serious issue involved in the case. The next one is lack of good governance. Here in this case, it is clear that the state administration failed to prevent the riots, and it shows the lack of effective governance on the part of state government. The next one is violation of social contract. The riots are taking place in cities and people are being killed on both sides. And there is also a huge damage to the public property. And it shows the clear violation of social contract where state is legally and morally bounded to ensure the safety and security of its subjects, which are the citizens of the country. And the last one is lack of role models. Now you must be thinking that how it can be an ethical issue. The idea behind this particular issue is that the political and religious leaders have failed to present themselves as role model for the youngsters. So we have discussed 7 ethical issues which are involved in the case. Now we will try to analyze what can be the way forward. Let us assume you are being posted as a SP in that particular district. Then how you will manage that situation? Then what should be the course of action you will take, or what can be the way forward so that such situations can be prevented in future? The first one is to ensure the inter-community harmony. It is the first and foremost thing which should be done to tackle such situations. To ensure the religious tolerance among the communities, we can arrange inter-community meets at regular intervals throughout the year. So it can be one of the solution. The second one is adopt stick and carrot methodology. Now what do we understand by this? It talks about the reward mechanism in which those who are doing good work will be rewarded by the administration. State can adopt this kind of methodology so that people who are contributing towards inter-community harmony can get due respect and reward, and while those who are disrupting the peace can be punished adequately so that others can take lessons from it. So it is a reward and punishment mechanism. The third one is ensure effective intelligence and administration. Accurate intelligence inputs are crucial to prevent any kind of communal disharmony, and effective deployment of forces during such events can also help in preventing riots. The next one is create employment opportunities. From this case, it is clear that most of the youngsters involved in the riots are unemployed, so if they are employed, such riots can be prevented. The next one is creation of role models. The religious and political institutions should create more and more role models so that common people can inspire and modify their attitudes as per their role models. So it can be effective strategy. The last one is politics with principles. Now politics with principle talks about the Gandhian philosophy, welfare of all, irrespective of their political or religious affiliations. By using such strategies, we can protect our people and promote unity and brotherhood among them. So whenever you come across such news, just try to analyze the ethical issues involved in that particular case and try to frame a strategy so that such incidents can be prevented in future. To summarize this, first of all, we have discussed the context, its relevance for the GS paper 4. We have also discussed the stakeholders involved in the case, the ethical issues which are involved, and we have also discussed the way forward for this particular case. Moving on to the discussion of next article, which is based on this particular news, which has appeared on page number 1 in The Hindu. The context of this news is that Tamil Nadu government has authorized a detailed inquiry by Directorate of Vigilance and Anti-Corruption against the former Chief Minister of Tamil Nadu, Mr. Palaniswamy. The allegations of irregularities relate to the construction of government medical colleges, government medical college buildings in violation of National Medical Commission norms. This article comes under the topic of corruption, which is directly mentioned in the GS paper 4, where you can find in probity in governance The sub-theme is challenges of corruption. So, this area becomes important for our discussion. In 2022 UPSC mains exam, a direct question on corruption has been asked in the GS paper 4. And similarly, in 2016, a direct question on corruption has been asked. So, it is an important area from which UPSC repeatedly asked questions. Now, in this article, we will discuss what the corruption is, what are the causes of corruption, and what are the legal measures in India against corruption. Firstly, we will see what corruption is. It refers to the abuse of power or position for personal gain, typically involving bribe or dishonest behavior. Further, it involves the use of one's public or private office for personal benefit or benefit of a group to which one belongs, rather than for the public interest or common good. In short, it is the misuse of office for unofficial ends. Moreover, corruption can take many forms, including accepting or offering bribes, embezzlement, nepotism, fraud, and other illegal or unethical activities. The impact of corruption is huge as it undermines the democratic process, weakens the rule of law, harms economic and social development of the country. We have seen what the corruption is and how it is impacting the development of our nation. Now we will see the categories of corruption. Most of you must be thinking that it is only restricted to bribery, but it is not. There are multiple categories and today we will be discussing all of them. The first one is bribery. It involves the act of dishonestly persuading someone to act in one's favor by payment or other inducement. For example, gifts, loans, and fees. The next one is embezzlement. It means the stealing or misappropriation of funds which are placed in one's trust or under one's control. The third one is fraud. It is an act of intentionally or dishonestly deceiving someone in order to gain unfair or illegal advantage. It can be political, financial, or otherwise. The fourth one is collusion. It is an arrangement between two or more parties designed to achieve an improper purpose or influence the actions of another party. The next one is extortion. As the name suggests, it includes the element of threat. It is an act of harming or threatening someone to gain advantage of some situation or to influence the action of other person. The last one is patronage. It means to give support to a person. It can be in the form of appointing people to certain posts. It means that support will be given to a person who will benefit the appointing authority. It can also be termed as nepotism, crony capitalism, in which certain projects are given to specific people so that the benefits can be taken out of them. So, we have discussed various categories of corruption in this particular slide. Now we will try to analyze the causes of corruption, why it is happening in our country despite stringent provisions and legislations against the corruption. Causes of corruptions include: the first one is lack of transparency. For example, the process of awarding government contracts. In many cases, the contracts are awarded without competitive bidding and there is no public disclosure of the terms or parties involved. Hence, it is one of the major reasons of corruption in India. The second one is low salaries of government officials. Many of you must have seen the traffic police officers taking bribe from people who have violated the traffic rules. Have you ever given a thought why these officers are taking money from those offenders? The major reason behind this is the low salaries of government officials, because the salaries which they receive is not enough to meet their basic needs. So it is an important cause behind corruption. The next one is weak enforcement of laws. The weak enforcement of laws give confidence to the people who are involved in corruption that they will not be caught after committing such crimes like corruption. The next one is political interference. Specifically in the appointment of officials, the political interference in India is widespread and politicians often interfere in the appointment of officials or influence the allocation of resources for their own benefits. It results into the practice of officials being appointed on the basis of political connections rather than merit, which further leads to corruption. The next one is complex rules and regulations. Let us take one example in which a person who wants to take a permit for construction of building, he has to go to multiple offices to get his work done. It is also a time-consuming process and he has to fill multiple forms regarding the same. This complexity creates opportunity for the officials to demand bribes in exchange of speeding up the process. Important cause of corruption. And the last one is lack of awareness among general public. Many people in India may not be aware that paying a bribe to government official is illegal, and they also do not know how to report the corrupt activities. And this lack of awareness make it difficult to address the corruption effectively. So we have discussed the major causes behind the corruption in India. Now we will take forward our discussion to discuss the legal framework for fighting corruption. The first one is Prevention of Corruption Act 1988. This act stipulates penalties for public servants who are engaged in corrupt practices. And in 2018, the amendments to the act made bribery a criminal offense both for public servants and civilians. Hence, if a person is giving bribe to the official, he will also be booked for the criminal offense. The next one is Prevention of Money Laundering Act 2002. This act aims to prevent the instances of money laundering and prohibits the use of proceeds of crime in India. It also includes the imprisonment of 10 years who are involved in money laundering case. The next one is Indian Penal Code of 1860. It has provisions which deals with bribery, frauds and cheating cases. And the last and recent one is Lokpal and Lokayukt Act of 2013. It establishes ombudsmen both for center and states to investigate the allegations of corruption against public servants, including the Prime Minister of India. These were the important legislations dealing with corruption. To summarize our discussion, firstly, we have discussed the context related to the state of Tamil Nadu, its relevance for the GS paper 4. We have also seen the 2 previous year questions of mains exam of GS paper 4. Further, we discussed what corruption is, the different categories of corruption, the causes of corruption in India, and finally the legal framework for fighting corruption in India. So that's all for today's discussion. Thank you for watching today's DNS. Stay tuned for upcoming sessions which will enhance your preparation for the mains exam and gives you wider perspectives on different news articles which are appearing in the newspapers.